Good afternoon. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to talk to you about options for those who have affirmative asylum cases pending. What to do if your asylum case is pending for a very long time and if you qualify for any other relief in the United States. So we're focusing on affirmative asylum, meaning that the person is not in court waiting for the interview. There is such a problem because what happens is that many cases are pending for a very long time, waiting for the interview for 2, 4, 5, 6 years. At times, a person filed the case well after the 1-year deadline, and the case is still pending. So what that person can do, is it possible to fix the status? Well, I have to say that the options are going to be very limited. That's number one. And they will depend on the way the person first entered the country, with inspection or without inspection, and if the person was paroled afterwards. If the person accumulated unlawful presence time, for example, and if the person would qualify for any humanitarian relief. So if there is a lawful entry, initial lawful entry, or subsequent travel on parole, and now the person can be sponsored by an immediate relative, which usually is a spouse, a U.S. citizen spouse, or let's say it's a son or daughter who now are 21 years old, then a person should be able to adjust their status to that of a green card holder and does not have to wait for their interview. Okay? If there is no legal entry and there is no prospects of being sponsored by spouse, if there is no legal entry and no prospects of being sponsored by the spouse, but there are U.S. citizen children and a person accumulated, or parent, let's say, and the person accumulated 10 years of continuous presence in the United States before they were served with notice to appear, for example, or committed certain disqualifying offenses, then a person may qualify for cancellation of removal in case he or she can demonstrate hardship to qualifying relatives. Unfortunately, this relief is available only in deportation proceedings or removal proceedings. When this will come into play? This usually will come into play if a person has been waiting for the asylum interview for a very long time, and if they filed their case well after they entered the United States, because they will need those 10 years. Because we all know, hopefully by now we all know, that there is a 1-year deadline to file asylum. So to have those 10 years, usually those 10 year relief will be available only for those who file their cases after the 1-year deadline. Let's say they claimed changed circumstances or changed country conditions, and they may be available, they may qualify for this relief. And by the way, nowadays New York Asylum Office started sending notices to people to request to waive the interview because they saw that the person filed the case well after the 1-year deadline, and they say, well, rather than you trying your luck with the asylum case, you can just go to court and don't waste time for the interview, go to court and request cancellation. Basically, that's what they're suggesting in their notices to waive the interview. Now, if the person now has a citizen or lawful or permanent resident qualifying relative who can sponsor them, but they did not have a lawful entry, they may be able to get a waiver, I-601A waiver, and get a visa. The only issue with that, of course, is that when a person is going to go for a visa and an I-601A provisional waiver, the interview will be scheduled as a rule in their home country from which they claimed asylum. So that's something that will need to be discussed with an attorney, how that can be addressed. The same situation will be if you have an employer right now or a lawful permanent resident spouse, you cannot adjust. You will need a waiver, or maybe you will not need a waiver, depending on when you filed your asylum claim. If you filed your asylum claim within 180 days of coming to the United States, right, before you accumulated that unlawful presence that's going to bar you from entering the United States, if you leave, then you may be able to get a visa based on a petition by an employer or relative, and you will not have to get a waiver if you do not have um, those unlawful days that will bar you from coming back to the United States. Because the way that unlawful presence 3 and 10-year bar work, they come into effect only after you leave the United States. And unfortunately, if you're not an immediate relative, meaning if you're not being sponsored by a son or daughter who are 21, who is a US citizen, or a spouse, and you're not somebody who has a legal entry, you will not be able to get a green card in the United States. As a rule, you'll have to leave the United States and come back. There are some exceptions, but usually you will not be able to. So we talked about the legal and entry or lack of thereof, what to do, unlawful presence. Now, the other thing that the person may qualify while they're waiting for their asylum interview would be humanitarian relief, so-called. There is U visa, T visa, S visa, or VAWA. In certain cases, and VAWA, by the way, is available sometimes to parents and children, not only spouses. So very limited relief, very specific circumstances have to be met, and you can watch other videos explaining statuses that I mentioned here to understand it deeper, how it works. Basically, sometimes some stuff is available, sometimes not, depending on the person's family ties, the way they entered, how long they've been here before they filed, and things like that. So hopefully this was helpful. And I recorded this video actually because one of you asked me to talk about this specific topic. So please comment and suggest more topics. And thank you for watching.